Good morning. Today is February 4th, 2025, and welcome to today's meeting of the Law and Policy Committee for the California Fair Political Practices Commission. Ms. Vo, will you please take a roll?
Commissioner Baker?
Here.
Chair Silver?
Here. Excellent. Well, let's start with our first item on today's agenda, and that's going to be public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? No? Okay, then let's move forward to approval of our June 2024 minutes. Any concerns with the minutes?
No, move to approve.
Excellent. Second.
Commissioner Baker? Wait, do we need to vote on these?
Oh, public comment?
Yeah, no worries. Do we have any public comment on the minutes? Okay, hearing and seeing none. Go ahead, Ms. Vo.
Commissioner Baker?
Aye.
And Chair Silver?
Aye. Excellent. Let's move on to item number 3, and that's our legislative update with Senior FPPC Legislative Counsel, Lindsay Nakano. Good morning, Ms. Nakano.
Good morning, Chair Silver, Commissioner Baker. Nice to see you both. I do have a ledge update today. Before I begin, I noticed we do have public comment in the room relating to, I think, potential legislation. So I'd like to invite that speaker up for public comment.
Good morning. I'm former Assemblymember Hector Della Torre. And when I was in the legislature, legislated quite a bit around what I considered good government issues. And recently I found out, and I did not know this obviously, that registered lobbyists can be appointees to state boards and commissions. And I don't think that's a good idea for folks who are getting paid to get certain outcomes from government, who have clients that have business before the government, for them to be appointed to these boards and commissions. So I think we should eliminate that, whether they're lobbyists or lobbyist adjacent. We all know folks who kind of blur the line a little bit. But I wanted to come before you to see if the FPPC would be interested in supporting that kind of legislation as a sponsor, and try to get this through. Because again, the conflict of interest is very obvious there for these folks. There's plenty of Californians. There's 40 million Californians. I don't know how many registered lobbyists there are. So there's plenty of people to fill these boards and commissions that do not have that conflict. So happy to answer any questions about it. I have talked to some folks in the Capitol about this. So, working on some draft language, that kind of thing, that could be the draft for you all to take it from there. And I'm happy to help in any way. I'm not a lobbyist. I am a member of the California Air Resources Board, appointee. And that's where this kind of came from, was, wait a minute, there's people doing what I'm doing who are lobbying on the side, or even possibly lobbying on the very issues that are before the boards and commissions they're on. That's not a good look. So anyway, happy to answer any questions. Thank you for listening to me today.
Well, thank you for coming today and bringing this up. This is a really interesting issue. And, I've appreciated our discussions previously discussing this issue. I think it raises a conflict of interest, like you pointed out. I think another aspect of this that's interesting is whether we would want to limit it to just registered state lobbyists, or perhaps others who potentially advocate at the state level. So perhaps employees of lobbying firms, right, that aren't lobbyists, that are still engage in direct communication. So with any legislative proposal, there's always different things to iron out. But in general, I think the spirit of this proposal is in the right place. One question that staff raised was this might not be a fit for the Political Reform Act, despite the fact that it relates to ethics. I think it'd be helpful if Ms. Nakano could touch on that point.
And thank you, Mr. Dilatori, for your comment and the idea. Staff did have a chance to look at your language and to review the idea, and without speaking on the merits, which I think Chair Silver has expressed, there's interesting issues there. Because there's a separate area in the government code that deals with appointments, appointing powers, and the qualifications for appointments, it's likely that that would be a better place just in statute for this proposal, which would place it outside of the Political Reform Act and outside of the Commission's jurisdiction. So that's a consideration just in terms of where it may be best fit in code.
Okay.
Commissioner Baker?
Thank you. Thank you for your service in the Assembly and what you're continuing to do and for bringing this forward. I'll start with the last point that Chief Counsel, Senior Counsel Nakano mentioned, and that is the jurisdiction. If we were to put it, if it's not prohibited to put it within the Political Reform Act, then it could be within our jurisdiction. Of course, it might be subject to a 2/3 vote. I'll have to try to remember the rules on that. But Ms. Nakano, do you see any reason why it couldn't be put in the Political Reform Act? It sounded like a different government code section might be considered more appropriate, you were saying, but it's not exclusive? Or is that the case?
I'm not aware that it would be prohibited because the Political Reform Act does regulate lobbying activity, so there is some crossover. I think we can look into it a little bit more and see what's possible there.
Yeah, and we can. I would encourage that, as well as the which one it's best to go in, what part of statute it's best to go in. I would definitely do it by statute for something like that. That's potentially a significant change. They'd have to also potentially look at the issues of. I think the chair was also kind of raising if you're a lobbyist employer and maybe it's just for 1 year and you no longer are hiring lobbyists at that point, how long is the prohibition? You'd have to look into that. As well as, is it for every employee? So if you're a large organization, you hire outside lobbyists to do their thing, but you have an employee that has nothing to do with that area of law. And in fact, maybe they serve on a education board because they care about education for their family and their organization is related to energy. So I think those would be things to look at, if just how far that's going to go. If it seems to be at its most core, a registered lobbyist, certainly within the subject matter that they lobby on, that would be important to look at. Everybody might have an initial reaction that that's not so great, but you got to see what the outer bounds would be, of course. And then finally, the other thought that came to mind, and I'm sure there'll be many more if this gets looked into further, is there are some boards and commissions where you do want folks with certain expertise. They may say on the optometry board, there needs to be a certain number of optometrists. I'm just giving an example. And then there's public spots, member of the public spots. We may have to look at, does this prohibition apply to the member of the public spot only for those boards and commissions, or will it also apply to subject matter expertise? And then an alternative could be is if you are a registered lobbyist and you are put on a board or commission, you are prohibited from lobbying on that subject matter. And you can define that any way you want, so that people who are registered lobbyists, if we feel like it's still appropriate for them to serve on boards and commissions, that there's just some offense that's put around their work. I'm rattling off ideas that come to mind because the issue was raised, and I think it's a good one to explore. So thank you for doing that.
Of course.
I think those are all excellent points. I think just to clarify my thinking in having a more broad prohibition rather than a narrow registered lobbyist prohibition is because I feel like there's a concern in the lobbying community that the individuals who are following the law and registering, and especially those who err on the side of caution, who, if they get anywhere near qualification, they go ahead and qualify, that they're being targeted, whereas colleagues who don't go ahead and qualify, or I should say, and don't register, even though they may come close to that line, they get to avoid prohibitions, restrictions that apply to lobbyists. So it's something that I think should be considered. I'd be interested to hear what IGA, intergovernmental, I forget what the acronym stands for, but what IGA's standpoint is as well. So we hope that you'll come back to our commission meeting when we'll have the full commission together to consider this proposal.
Appreciate
And
it.
in the meantime, please feel free, and we encourage you to communicate with our staff.
Thank you very much. I appreciate you taking the time to hear me out.
Our pleasure. Thank you.
Thanks.
Okay, Ms. Nakano, you can move forward with the legislative update.
All right, thank you. The legislature is in full swing. So far, 3 PRA-related bills have been introduced. Those include an intent bill, 1 commission-initiated proposal, and 1 other bill. We have confirmed authors for 5 of the remaining commission proposals relating to cryptocurrency, preventing foreign interference in state elections, reporting of behested payments, expanding the prohibition on making contributions in state buildings, and disclosure of prospective employment. We have interested authors also in the CARS cleanup bill and are in communications with the Secretary of State's office to coordinate further on that. I'll go over the introduced bills. First one's AB 359 by Assemblymember Ramos, and this is one of our commission-initiated bills relating to the extension of local contracting authority. As you've heard previously, when I discussed these proposals, this would delete the sunset provision that would end the authority for the FPPC to contract with local government agencies to administer and implement and enforce their campaign finance and government ethics laws. So this would allow the commission to continue doing that indefinitely upon mutual agreement with any interested local jurisdictions.
And Ms. Nakano, just to ensure that we comply with the ex parte rules, I think it's worth disclosing that you and I met with Mr. Ramos' staff to discuss this bill and them being the author for it. For the few viewers that we have here today, there's going to be quite a few ex parte communications to be disclosed, and that's because as chair, I'm really emphasizing my participation in the legislative process and working closely with Ms. Nakano to make sure we get authors for these very important bills.
Sounds good. I'll move on to the other 2 commission-related bills. First one is a spot or intent bill. It states intent partially relating to the Political Reform Act, although it may or may not be amended in the future, and it's unclear exactly what that language or substance would be. I'll keep the commission updated. And AB 351 by Assemblymember McKinnon. This one will look familiar as there was a similar bill last year. This relates to Section 84308, or contributions to agency officers, and also governs when they are required to recuse themselves in making government decisions. The bill would increase the contribution limit in that section from $500 to $1,500 and would require the commission to adjust that amount biennially. This, for a reminder of recent history, the amount was raised from $250 to $500 last year, effective January 1st of this year. So this would be an additional increase.
Any explanation from the author's office as to why they arrived at 1,500?
I haven't spoken to them this year. I'll have to go back and look at the committee hearings as to how the author explained this change, but I can look that up for our next for our commission meeting.
Okay, thank you.
Okay, couple other things I wanted to bring to the committee's attention for discussion relating to commission proposals. The first one has to do with the disclosure of prospective employment proposal. I know there had been some discussion about how broad it should be, who it should apply to. I think there are 4 options for how broad we could make the bill. The first would be elected officers. Second, elected and appointed. Third, elected and full-time or salary appointed. And then 4th would just be all filers. So there's a lot of options for how we put parameters on this bill, and open to the committee's discussion of that.
Great. Well, thanks for laying that out. I think it'd be helpful for us to know at the commission hearing later this month whether the legislature has previously introduced any sort of expanded disclosure that's limited to elected officials or appointed this sort of situation. When I say expanded disclosure, specifically expanded disclosure on a Form 700, that sort of thing. That's one thought that I had. I think this is a really good question and something that I'd love to hear from the rest of my commissioners on. I should say our commissioners. So especially Commissioner Baker. Commissioner Baker, any thoughts on that?
Thank you. And I know I probably rattled a few off at a prior meeting, but the ones that immediately come to mind, I do feel that I would continue exploring the scope of the appointed positions, because I do think in addition to elected, appointed could be quite a significant role. The suggestion you made for between option 2 and 3, where 3 would be only, I don't know if you meant only salaried appointed. Of course, there's per diem, and then there's salaried full-time chairs. The spectrum changes. I think I probably am a little more expansive on that, just because the person has a vote, the same as the salaried member. And on this commission, for example, the chair is the only full-time commissioner, and it has quite a leadership role within the agency, setting the agenda, and really so much more than other commissions where you might have a 6-figure salary, but you are attending, you're not in the administration of the agency. And so I think I would try to explore, really take a look at what are the different types of appointed positions that we want to be considering how this would play out in that respect. And I can't recall if I raised this when this first came up, but the issue of local appointees. So if someone's appointed to a commission that the local agencies decided, everybody here is going to file a Form 700. This is nothing against people who serve on the Library Commission, but for example, you serve on the Library Commission. You're perhaps not, your jurisdiction isn't as broad as, say, a planning commission or a city council. But they're a Form 700 filer because the cities can make that decision, if I remember all this time on the commission now at this point. They can decide if they would like who in addition to who's required under law files a Form 700. I think we want to be mindful of that. Do we really want to have both the potential disincentive? I don't know, but that person, and for us administratively, to inspect these things and look for compliance, are we creating more work where we really want to be focusing on certain filers? So that's the other point that came to mind, is how it might affect the very local positions for which state law isn't really driving who is filing the Form 700, it's local decision makers. And I'm happy to be corrected on that if I'm wrong and a city can't decide who does Form 700. I know that the state can decide if somebody who's contracting with the state has enough of a role that it may not be required, but you have to file Form 700, and what the implications for that might be on being able to contract. So those are all the ones that come to mind for me. I would look into more. And I'm not sure, I had a separate question for you, but it is, how far in the process are we with potential authors on either both chambers or both sides of the aisle on this particular one?
We
Thank
do
you.
have an author who has expressed interest in authoring and in claiming it. The exact parameters, obviously, we're still working out, but they are prepared to move forward with the idea.
Thank you. Those are just the ones that I would be continuing in the coming months to work on, and including particularly that appointed position. I feel like elected is a little bit more straightforward, for sure. But appointed, it can be messy, and we want to make sure it's both administratively monitorable and it really captures the people that we'd like to, knowing that different commissions, an appointed position means so much more. They all have a vote, so.
So I think you make a really good point in terms of the scope, right? Especially at the local level. So I think if it's not already, clear to the author, I think we'd want to make it clear that this would be tailored to the disclosure category of the specific official, right? So if you have, let's say we end up going with everybody, if you serve on the library commission, and you end up agreeing to employment with a entity or individual that's not under the library's jurisdiction, that's not the sort of thing that the public would expect to have disclosed, right? And we could potentially even have constitutional or legal issues with that sort of expanded disclosure. So we'd want to make sure that the types of prospective employment, the range prospective employment that's disclosed, is the type that relates to their position, to the decisions that they're making. So I think that's a really important point. That's already in place for all the other economic interests that could give rise to conflicts or disclosed on Form 700s. And I don't know the mechanisms that are in place to make sure that those disclosure requirements, conflicts of interest, are limited specifically to that disclosure category. So I'd want to make sure that this would have the same sort of tailoring. So I think that's important. I mean, my gut reaction is that this is a relatively easy reporting requirement, disclosure requirement to comply with. And it would be, assuming, my assumption is correct, that this would be the first time that we have supported an expansion of disclosure which is limited to a specific segment of public officials. That probably the prudent way to go would be to have it across the board, so there's no confusion about where it's applicable, where it's not. However, this is a completely new requirement. There's a lot of public officials in the state of California. We only have so much resources to educate the public officials of California on this new requirement. The last thing that I think the commission wants is for people to violate the law unintentionally because there's a new requirement that's placed on top of other complex requirements, especially for part-time appointments. But then you're also balancing what you pointed out, which was the gravity of the decision-making authority, right? And I think the public really wants to know if someone's part-time or if they're full-time, whether they have a conflict of interest. And without this disclosure, there's essentially, correct me if I'm wrong, no way for the public to know whether there was an arrangement in place when a decision was made. Subsequent, they could see whether the individual received income, right? But they're not going to be subsequent to their employment, that is. But before that, the public's not going to be able to know whether there was a potential conflict. So, Commissioner Baker?
Thank you. I appreciate that. As you're trying to narrow it by saying that if you're on the Library Commission and the position is unrelated to jurisdictional Library Commission, I think the first thing that came to mind is that could be very difficult for how people will get guidance. So how will they know? It might seem straightforward. We're really taking this Library Commission example far,
I'm
but
sure they're very nervous right now.
or dog park commission, whatever. That if maybe it's an employer with I don't know, something, a pet supply company, and then so is that considered it? And I can just imagine if I'm someone who is trying to comply, I'm looking at a piece of paper here with a Form 700, do I disclose this or do I not? I think that may run the risk of actually making it more complicated. And perhaps we focus on more bright line rules. You're a state elected or appointed board or commission, which I'm sure there's a definition of we can find. The decision has to be made about salaried or not. I would encourage that the salary doesn't matter. And with respect to local, where local jurisdictions have the ability to do a Form 700 requirement themselves, I would be very nervous about trying to say, is it in your jurisdiction? I think it may raise more compliance concerns, make it more difficult. Some of it will be very easy, but some of it will be really fuzzy. I suppose they could just decide, well, I'll disclose it anyway. But let's say they don't, and then they get smacked with potential violation. When that's not our purpose, is to make this, how fuzzy can we make it? Bright line was probably what we're really looking at. So not to poo-poo your idea, because I think it was going in the right place, but we got to really watch if we're making it harder. We-
So
Come-
limiting
yeah.
the state officials would allow us, state elected and appointed, at least state elected would allow us to avoid the issue of having officials having to consider the disclosure category for disclosure of prospective employment, right? Because I believe all statewide electeds have full statewide disclosure. So that's one benefit. If we do locals, you're going to run into the issue that you just mentioned, that they're going to have to look.
Local electeds?
Well, local electeds, if you look at local appointeds, local 87.3 code filers, they'll have to look at their disclosure category and their conflict of interest code, just like they do for income, right? Or gifts or stocks and bonds, investments, that sort of thing, and then make that determination. So it is a little bit more complex and something to consider. So if we limited it just to state elected officials or state appointeds, we would take some of the complication out of there. I'd be interested to hear from legal as to whether my musings are actually legally correct. So,
And if I may, Chair, I would also, I'm not sure I would take out the local electeds. You know, you can have City of Los Angeles City Council member or County Council, sorry, Los Angeles, I'm not picking on you, but, or San Francisco or a very small town somewhere else. You know, I feel like elected is a little bit more of the bright line. It's the appointed at the local level and trying to narrow it, either just make it a brighter line, as opposed to you have to decide if it's in your jurisdiction. I think with an elected, it's a little more straightforward. You're elected and yep, generally you're going to file the Form 700 anyway. With appointeds that's local appointeds, that's where it's getting fuzzier for me. That's just my feedback on that one. I'm not sure I would take out local electeds, county supervisors and school board members and city council members, water board, bring the whole thing. I see that our director is grabbing the microphone.
Executive Director West?
Yes, so it sounds like you guys are getting to 87-200 filers versus code filers. So we do have things in the act that are already set up for differentiating. So why don't we go ahead and take a look at some different options and present that to you at the next LMP.
Excellent. Okay. So the author that we're talking to, we talked to Assemblymember Berner's office about this bill. We also talked to Assemblymember Addis's office about this bill, and I believe Senator. I think those are the two. Okay. Great.
Okay, thank you for the discussion, and I will consult with staff on further ways to differentiate. Okay, the second proposal I'd like to bring up relates to the reporting of behested payments. I think when I introduced this idea to the commission previously, it was limited to requiring state elected officers and members of the Public Utilities Commission to file directly with the commission using the commission's electronic filing system for behested payments. Since then, staff has been analyzing the behested payment sections and other areas where it would be beneficial to make additional changes. And one of those areas relates to local elected officers. They are in the same section, so there are decisions to be made about how their filing requirements or how they file should or shouldn't change. There are a couple options for them. Currently, they file similarly to at the state level, they file with their agency, and their agency forwards it to their local filing officer. Under the proposal, the first option is that they could file their reports directly with their local filing officer, similar with at the state level, they'd file directly with the commission. And then the bill would authorize local jurisdictions to have an electronic filing system for those individuals. And then the second option would require local elected officers to either file their behested payment reports directly with the commission, similar to or the same as other filers at the state level. And then they'd have the option of, instead of that, they'd be allowed to continue filing with their local jurisdiction if all of the reports, the behested payment reports for that jurisdiction or agency, were posted publicly online. So as long as we had public access to those reports, either locally or through our system, they'd have that option. And the benefit there is that not all local jurisdictions post their behested payment reports easily available online for the public. They are requestable, of course, but they're not all immediately available. There are some other elements to the proposal, so happy to stop there if there's any, or pause there if there are any questions about that element.
Sure. Before we touch on that, I just want to compliment yourself, legal division, on crafting this bill. You did an excellent job listening to the concerns that were raised by good government groups, by the media, by the regulated community in the behested payment context. And I think that you crafted a bill that really addresses those in a way that I don't see much downside. I think in terms of, first, transparency, for the reasons you're talking about, I think this is huge for transparency, right? You have lots of local jurisdictions who do not post their Form 803s online. Frankly, it's an area of disclosure that's not that well known, right? Certainly not as well known as the Form 700 or your campaign finance disclosure. So I really think it's important that the media, that the public has the ability to access these quickly and timely. And on that point, also right now, you have potentially up to 60 days before a behested payment report is going to be posted on the FPPC's website. For instance, if they're a state filer and we're currently the filing official for them, this would reduce that in some situations, number one. And number two, what it would do is it would make it so the media would know exactly when to review these payments. They would know when these payments are going to be disclosed. Right now, reports are filed within 30 days of the $5,000 threshold being met, right? And then they're filed with their agency and then forwarded along to us. There's not a clear timeline as to when that report's going to get to us and it's going to be posted online. With the infrastructure, the framework that we've set up here, the press is going to be able to look 30 days after the calendar quarter, I believe is the timeline. They're going to know these are the behested payments that were made by the governor. These are the behested payments that were made by the assembly member for this specific district. And they're going to be able to look at that further without having to come to our website every single day and see if we uploaded new data. I think that's really powerful. So with that, as far as the distinction, those two options, my priority is that you have those local officials Form 803s posted online. How that gets done, whether that's on our website, whether that's done by local agencies who have spent their resources producing their own e-filing systems, infrastructure, I'm willing to hear arguments from both sides. I just think transparency is really important on this issue. And I will stop, I'll get off my bully pulpit and give it to Commissioner Baker.
Thank you. I'm going to focus, I'll be interested in hearing the other provisions, including potentially the calendar quarter issue. But with respect to the first chunk that you bit off, I'm very much supportive, and I think we all can be here at the commission, is getting them online. In an ideal world, folks will still be dealing with the question of, maybe this is the not ideal world, okay, do I go to the FPPC or do I go local? And they're just not going to know. They're going to have to, that's still an issue. And then we've had that, I think, with other forms over the years, is where am I going to find this form? Is it at the local level or the state level? So if this is what we can accomplish for this cycle, which is they're online, they might be local, they might be at the FPPC, but at least they're online, that's better than the current situation. We may, down the road, see if we can continue working on something that is even more clear for the public. I'm always, in the media, I'm always going to go here and I'll be able to find them. I think that would be the ultimate goal. We may not be able to accomplish that with this when we've learned that jurisdictions have their own systems that they feel are not broken. Please don't fix them. And the fix that we are going to try to get is that things are just up and online for 803s. But I'll wait. I'm very interested in hearing those other provisions, and especially the 30 days after the calendar quarter. Can't wait.
Okay, I'll move on. As the chair has hinted at, one of the other elements relates to when these reports would be due. Right now, they are due within 30 days from the payment to the agency. So, for example, in the legislature, the Senate or Assembly, or for other agencies, the office themselves. And then that the agency has 30 days to forward a copy to the commission. So there could be 60 days currently between the payment and when it gets to the commission. The proposal would change the filing deadline to within 30 days after the end of each calendar quarter. So if the payment was made anytime in the first quarter, they'd have 30 days after the end of the first quarter to submit their behested payment report. And the reason for this, as the chair mentioned, is this would give some more certainty for both the filers and folks who are interested in looking at these reports as to when they'd be filed. It would also alleviate some of the burden of behested payment reporting, as it can be challenging for folks to get this information from the donor, since the payment is between separate parties.
Commissioner Baker. Oh, one last thing, just a note. I don't know if you mentioned this, Ms. Nagano, is that it would adjust the threshold for the disclosure once the $5,000 initial $5,000 threshold is triggered as to a single source. So, for example, if a elected official behested a payment, a donation of $10,000 to the Red Cross, right? And later on that calendar year, that same source donated a $10 toy at that elected official's toy drive, holiday toy drive. Under current law, that $10 toy would have to be disclosed within 30 days. So this would raise that to $1,000. So for example, if you had an individual, say you had an elected official who asked me to make a donation, I made a donation of $10,000, that's triggered. Then they send out a recommendation, a suggestion that I go ahead and donate blood to the Red Cross. The value of my blood would be more than a penny. And technically, under current law, they would have to go ahead and file a Form 803 disclosing my in-kind donation of blood. So I assume that is not what the intent of the legislature was when they passed this law. But, I'm open to arguments on that. Commissioner Baker?
Thank you. Appreciate learning the provisions and that there's an examination of all these issues. And I think they certainly start with a good goal. I think I am very cautious about the extension of the filing to this one commissioner to the per quarter, as opposed to the 30 days, or if you wanted to extend it 60 days. 30 days is a tight time frame. In this modern world, believe it or not, it's a tight time frame. But the reason for that is the purpose of the information is to see another potential avenue of influence that is used in government. And just that's why it's out there. It's not a prohibition that an elected, for example, can't ask someone to give to a charity. The purpose is to make sure they know, because maybe that entity has reached the campaign contribution limits or other limits on how they can exert influence, and this might be another way. It's the most cynical way of looking at all the way the world works. And by changing this to 30 days after the calendar quarter, you can go well past an election. So if the election is in November and the contribution is made in October, you won't know about it till after the election, as opposed to potentially before the election, or at least very close in time, like more immediate. So I need persuading that's the right route to go. I know it's administratively very beneficial. And the same for when decision-making happens. We're using the legislature an example because that's the one I'm most familiar with, but you can see it from local government. Lots of bills are voted on during House of Origin and end of session that are substantive and important. And there's other ways that people try to influence and build friendships and relationships with decision makers right around the same time that a vote is happening. And I think the public cares to know, and the media, who hopefully still help them watch these things, that right around the time when a big bill was passing, an organization company, somebody gave $50,000 to a charity at the behest of an elected official who voted on that. So I'm not sure that the existing timing is convenient, and it's got issues, and we've tried to make it easier to comply with the existing time frame, but I don't know that it's broken enough to change it to a 30-day after a calendar quarter, given the importance of timely transparency, not just transparency, but timely, particularly when there are elections. And a quarter is quite a bit after. So that's my feedback on the time change, this one, Commissioner, and I would encourage us to really look into that, because I'm not sure I'd be comfortable supporting the time changes. But I know these are early days working through it. The subsequent 1,000, the blood example is a great example, and the $10 toy. I'm also trying to see, is that broken? Is that amount broken? Is 1,000 at a state level might make sense, but if it's a local government level and it's another $1,000, folks might feel like that is a lot of money. So it's certainly good that it's a clear dollar amount, like it's $1,000. It's not some formula, and we're not trying to catch the de minimis. But I feel very cautious about both of those, especially the first one. With respect to the chair, that we're trying to see what improvements can be made to behest payments. So feeling cautious. I might be persuaded on the raising the subsequent amount to when it's over $1,000. Are you anticipating that the $1,000 is just for one, or that's $1,000 cumulative? So I want to see if we're creating a way for a group or entity to stay under the radar.
But before I touch on that, I think you're right to be concerned. I think whenever we're making any sort of disclosure requirement less strict, like we did with 84308, that sort of thing, I think we should take it very seriously. So I'm absolutely open to alternatives. Like, we're open to alternatives in terms of timeline. I think one thing that we have to acknowledge is that currently, let's say, the example you gave, we have an assembly member, a senator who directs a payment before a vote. Technically, they can delay within the law 60 days before that's provided to the FPPC. And then once it gets to the FPPC, then it has to be processed and before it can be posted. Under this, if we did calendar quarter, there would be required disclosure regardless of when it was made during the quarter within 30 days, just like lobbying reporting. So there's certainly the possibility that you could end up with a 59-day period for many of these payments, which would result in quicker disclosure for the public. Nonetheless, that's kind of a technicality, and I think what the public is going to see is, hey, they're potentially going to have more time to do this. So valid concerns. Interested to hear what the rest of the commissioners think. I think for me, I think the practical concerns for the regulated community as well as the media and the public in being able to identify this sort of influence that the legislature has made clear is important for us to keep an eye on, I think is important to consider as well. Right? I wouldn't expect that the member of the public is going to look at our website every single day during the month to see if new reports have been filed. Same story at the local level. You have a local activist, that sort of thing. They would have to, under current law, they in many jurisdictions can't even just go online and look them up, right? So they would have to submit CPRA request after CPRA request to get all those documents every single day rather than just looking at the single report that comes out at the end of the quarter. As far as whether we would look at payments in the aggregate, I think my assumption would be that for that $1,000 threshold, you would be looking at payments in the aggregate. You wouldn't look at solely $1,000 behested payments once that $5,000 threshold's met. So if somebody subsequently makes 3 donations of $400, that third payment would trigger an additional report. But I think that's a valid concern, and that's something we want to make sure is clear in the statute, so that can't be a loophole. Go ahead, Commissioner Baker.
Thank you. Thanks for considering those ideas and the exchange. On the last issue regarding the $1,000, how much is this an issue? Like, have we been finding that there's a problem? That once somebody hits 5,000, they don't know that there is a problem? What prompted the $1,000? Maybe it's us, but I don't know if it's potential authors or internal staff. Is there a problem that we're trying to fix by doing that?
I think this came up because the initial threshold is $5,000 from a single source in a calendar year. And if that donor contributor makes any other amount of payments at the behest of that elected official, the elected official has to report. So whether it's $100 extra, whether it's a very small amount as the chair gave in his examples, the elected official would have an additional reporting duty. So I think staff were considering whether it was how much value there is in reporting that extra $100 from that same donor who already has an initial behested payment report reporting the $5,000 or more previously. So I guess it was consideration of balancing the value of the additional report plus against the burden to the official, and what is going to be something that the public would be interested in. Are they interested in a $100 payment, or would they be more interested if the payments cumulatively were higher?
If I may. So is it staff initiated? Okay. And I would be curious, when we address this potentially as a full commission, what volume of these additional, how often do we really see that happen? That it's below the $1,000 threshold? I mean, that might take an amount of looking into, but for me, it's good to be data-driven on something like this. I imagine I would like to know if the bulk of subsequent reports after the $5,000 hit are over 1,000. And so this would be capturing, this, maybe not changing very much, or it would be changing, maybe it's most of them are that amount. As the chair pointed out, I mean, there's a lot of people, particularly at the local level, who have no idea they are bound by behested payment reporting. And this particular aspect of it, which is once it hits $5,000, you got to keep doing it. There's questions of within a calendar year versus, prior 12 months. That's a whole nother point that they often don't know. But I would be interested in data driven on this to see just how much of an issue. And if they look to ask, how far back do you want us to go, Commissioner Baker or otherwise, I'd certainly go back in the last 5 years. I'd really like to know how much of a problem this really is with numbers. Thank you. For me to decide that, for this one commissioner's point, that it's a good adjustment to make. And I also think that every time we change something, different thresholds, this is quarterly versus semi-annual reports, 90-day pre-election reports, and otherwise, maybe it's 60-day. You really are getting into the compliance for people. There's always a different calendar point. So I'm hesitant to change something if it's not broken.
Thank you.
I think that concludes what I'd like to bring up today, but happy to answer any questions or about anything else.
Great. Ex parte communications that disclose here. I believe we spoke with Assemblymember Wilson's office about this bill. We spoke with Mr. Fong's office, Assemblymember Mike Fong's office. So any other meetings that you recall?
Not off the top of my head.
Okay, excellent. Thank you. Commissioner Baker?
You can see this comment coming, which is I know you're going to be reaching out to members on both sides of the aisle at the early stages, because the more, and I think you've already had some success with some of the legislation for doing that, and I'm grateful for that. I always find that it's anytime we can be encouraging bipartisan collaboration for what little role we play in government, the better, and the solutions tend to be a little more balanced and long-lasting when that happens. So thanks for continuing that work.
Thank you.
Excellent.
Okay.
Any other items in the legislative update?
No, I think we're making good progress. We have authors, and so I expect to see more introduced bills in the near future.
Perfect. Well, thank you so much for your hard work on this. We really appreciate it. Any public comment? Okay, hearing and seeing none. Thank you again, Ms. Nakano.
Thank you.
We can move on to item number 4, discussion of possible FPPC response to wildfires in Los Angeles and Ventura counties, including regulatory and legislative action. And we're going to have our General Counsel, Dave Bainbridge, presenting on this item. Good morning, Mr. Bainbridge.
Good morning. The commission at the last commission meeting a couple weeks ago instructed the legal division staff to draft regulations that could address delaying the filing of annual SEIs for officials affected by the fires down in Southern California. Simon Russell, our newest counsel in the legal division, prepared 2 options here. One, and this is within the authority of the FPPC because the statute specifically says that our commission will set the deadline for filing annual statements through regulation. So the 2 options we have here, one is just addressing this specific issue. So it's essentially a temporary regulation that would give an extension to those officials affected by the fires in filing. We set a number of days. I think we set the deadline now from April 1st to June 1st, I think is what 180 days. This is obviously a number that can be changed. That was just what seemed to make sense to us. The other option was an idea we had because this is not the first time this has come up. It came up during COVID. That obviously was a lot closer to the April 1 filing deadline, just a couple of days before we actually ended up adopting the regulations April 2nd of 2020. But because it has come up before, this option would give the chair of the commission the authority in instances of emergencies to provide an extension on the filing of SEIs. So rather than every time this comes up every few years, hopefully less than that, but it's been 5 years in this instance, the chair could make this determination of extending the filing deadline. We have some parameters in place limiting it to instances of emergency as that is defined in statute elsewhere. So these are 2 options for the commission to consider. We will notice this with the Office of Administrative Law. Commission can't take action on these items until March, but we wanted to get it to the commission so they can have a discussion and consider the 2 options or decide nothing needs to be done or whatever direction they want to go. We noticed it fairly broadly, so we can take input. We are not stuck to these 2 options. We can modify them somewhat if we want to change the days or who's the decision maker about allowing the extension, and those sort of things are all up in the air. But we wanted to get pen to paper to give some options to the commission. So open to hear the thoughts of the committee. We plan to present this to the commission at the meeting next week.
Okay, great. Well, thanks for laying this out and for preparing this on such an expedited basis. Quick question. I just want to understand the landscape here. We have a lot of different Form 700 filers in the state of California. So this is going to apply specifically to what class of Form 700 filers?
This will apply to those annual filers under 87-200 whose statement is due in April. There's a handful of offices that are due in March. There's nothing, we have the time to do anything about those at this point. But the majority of them file in April, the 87-200 filers. So this would affect them. It also would affect all of the code filers, the 87-300 filers, who adopt our model code for their code, because that has the timing of April 1st for filing. There may be a few agencies out there that don't use the model code that our regulation has for timing of filing, but I think most of them do use that code. So it would be those 2 groups.
Okay, and then the 87-200 filers that wouldn't be impacted by this because they're March filers, who are they?
They're listed in the memo in a footnote.
Okay.
It's provided for in our regulation too as to who are the May or the March filers. Governor, Lieutenant Governor, Attorney General, Insurance Commissioner, Controller, Secretary of State, Treasurer, Superintendent of Public Instruction, members of the legislature, members of the State Board of Equalization, judges and commissioners of courts of the judicial branch, members of the PUC, members of the State Energy Resources Conservation and Development Commission, members of the FPPC, members of the Coastal Commission, members of the High Speed Rail Authority, and then members of elected to the Board of Administration of the Public Employees Retirement System. Oh, one more. And Board of Administration of the Teachers Retirement Board.
I love that Executive Director West is just reciting it off the top of her head. So here's what I'm thinking. Out of all those public officials that you mentioned, I think the only ones that are going to be primarily based in the area impacted by the fires are going to be the judges and the court commissioners. I could be wrong. Sounds perhaps some members of the Coastal Commission as well. Since our hands are essentially tied here as the annuals, I think it'd be helpful if we make it a priority for the SCI unit or whoever's appropriate to reach out to that small segment of 87,200 filers and just make sure that they understand that we're here to support them and that we have materials that can help them in figuring out how to fill out their Form 700 and ultimately submitting it. Just making sure that they feel supported and potentially explain the situation to them if we ultimately go ahead and adopt one of these regulations and take action that would push back all the deadline for all the other code filers and 87,200 filers at the local level. Okay. And then an excellent point that was made by Commissioner Baker at the last meeting was perhaps the public officials who are going to be most impacted by this in the Form 700 context is going to be those who are assuming office and leaving office. How are their situations being addressed?
The commission doesn't have the authority to address that situation. My understanding is the governor's office is looking into addressing that for them, but there's not been an announcement about a final decision on that.
Okay, that's helpful. Commissioner Baker?
Thank you. Just on that question, so that means the governor has an authority here is there some authority that the governor's office, the governor, has with respect to the March 3rd folks that we don't? Is there something that the governor, this might be outside what you looked at, could do? Since we are limited, I appreciate the chair identifying folks that might be the most obvious for how they could be affected, and if we could reach out to them. We just don't know if somebody's on a commission for something else, one of those others that were listed towards the end that lives in Los Angeles and their house is burned down. We don't want to be too anecdote driven here, but if there's any way the March 3rd folks could also be addressed by the governor's authority, do you know anything about that?
The governor has the authority in times of emergency to rescind or modify certain statutes. So to the extent they have the authority to modify the act, the PRA, which the fact that they're considering this makes me think they believe they do,
Okay.
they could modify the deadline for March 1st filers.
Okay. I appreciate, I don't know if we want to, if the chair is in touch with the governor's office and getting updates or how this is, we may consider respectfully saying that if we feel this way as a commission, we would do something about this if we could. At least this is how I feel. We'd give a similar extension to them as well as the assuming office and departing office so that it's both clear and we just cover folks who down in that area may, regardless of what office they hold, they may have been terribly impacted by the fires. That might be the most we could do with respect to the March 3rd folks and catching anybody else that we have. I would be okay with sending that message, even if it's informally. The question I have is not on this point about assuming or leaving office or the March 3rd folks. It's how we're defining, because you mentioned the fires in people affected by the fires in Southern California, which is certainly in the Los Angeles County area. But I think also there was Ventura and there were some in San Diego that maybe were had less people fewer people impacted. Can you explain what thoughts gone into how to define who is covered by this in terms of jurisdiction?
Sure. If you look at option 2, what we're proposing is language that says an official whose primary residence, primary work location, or filing office is located within Los Angeles County or Ventura County. So fairly broad.
Okay.
Haven't drilled down on exactly who. I think we figured it'd be too difficult to figure out exactly who was impacted and how. So since it's a 60-day extension, we thought make it fairly broad to everybody in the counties.
Yes, and I agreed with that. It's, I'm thinking, for example, of San Diego. What I don't want to have happen is we do this and there's just a portion of San Diego that is affected. I don't know how much, I'll just confess, their fires at about the same time did this. Don't have a problem with the way the language is now. I just wanted to know what went into not including San Diego. Maybe they just weren't as impacted.
So, I would take credit for that. I highlighted Ventura County and LA County as the two areas that were impacted.
Okay.
I'm unaware of the fires in San Diego. I think it's certainly something that we should consider. It's my understanding, and we have been in discussions with the governor's office about this and the legislature as well, that there may be questions as to what the scope is going to be. I think that's something that we can consider as we go forward with this.
Thank you, and that's for taking credit. That was my only other question that I had, was just in the jurisdictions. And who's affected. I think certainly Ventura and Los Angeles County seems to be the primary source of the tragedy. So thank you. With respect to the additional option of having emergency authority within the chair, I don't have an issue with that because it might be good to be able to have a quick response and have some parameters around it. I also don't know what other alternatives are explored because we can meet fairly quickly. Like law and policy and the commission can call a meeting. We've done it before when it was very quick because we need to act by a deadline. So I don't know that that's as urgent a need, but I don't have big objections to it.
Well, I'm glad you brought that up because that was something I was hoping that you'd comment on, because I had some reservations with it being solely at the discretion of the chair, right? Especially given what you laid out, that the commission could do an emergency meeting and come in and provide an extension. Practically, if we went with the regulation that would create this framework where either, let's say, here's the specific example. We go with the framework that allows the commission to extend the deadline rather than the chair, and we adopt that at this month's meeting. Would we then have to call essentially an emergency meeting after that in order to timely extend the April 1st deadline? That's the first thing that I thought about when making that change. That was my concern there.
So the way the current language is written, the chair could grant this extension or order this extension. It would be effective upon the chair granting it. It would just then be reported to the commission at the next meeting. So to answer your question, if this regulation is adopted, the chair could then issue the order extending the deadline for filing on April 1 immediately after the commission approves of the regulation, and then would just report it at the next meeting.
Sorry for my word salad. What I meant was if we replace the chair as the authorizing authority, right, with the commission, the majority vote essentially the commission, how would that impact this practically?
You need 10 days to notice a meeting.
Okay.
So from a practical standpoint, we would have to have another meeting after the March or the March meeting. If you adopt the regulation in March with the understanding that the commission will have to vote to approve extending it as opposed to the chair doing it on their own, we would then have to hold another meeting before the end of, or before April 1st, I guess, to approve of that. But we have when's the March? I'd have to check the calendar here for the March meeting date. Stand by. Yeah, well, we're getting close. So the meeting's on the 20th. We could call, I guess we could call a special meeting at any point. I mean, we could have it on the 21st, right? And the commission could approve it on the 20th and then on the 21st have a meeting.
So what if we did this? What if we changed the authority to extend the deadline from the chair to the commission, right? And then also adopted the second version that specifically provides that extension for LA County and Ventura County. So we would resolve the issue of having the extension, right? And that would be done based on the consensus of the commission. And then moving forward, which, my main concern here is I don't want us to be in the business of deciding what's a public, an emergency situation versus what's not. So in the future, we can avoid that dynamic by having this other regulation in place that allows the commission to make this determination together. And if there is an emergency like COVID where, you're close to the deadline, we can do an emergency meeting. Commissioner Baker? Oh, go ahead.
We could certainly adopt both options. I forget which one's which. The authority for the chair in all circumstances could be adopted at any time. That's not time urgent if you adopt the first one like you suggested. So it'd be a temporary regulation specific to these fires, and then we could then adopt another option. Might put it off a meeting just to make things less complicated for the Office of Administrative Law to adopt the second one, giving the general authority of the commission to then give exceptions in times of emergency.
Commissioner Baker?
I definitely would just adopt the one with respect to LA and Ventura, keep it clear, make sure at our next meeting. And so that we just go forward with that and we're less in the issue of calling another one and so on. With respect to going forward, what do we do? Because we want to kind of anticipate. If we're going to put commission language, which I would agree with, I think there's a benefit to having, not necessarily me, but other commissioners weigh in. They'll think of things that you or I may not, whoever's chair. And then B, do we already have that authority? Like if we're going to substitute that language, how much does that change the emergency authority we already have to act quickly? Is it that we don't have to wait 10 days?
No, it's how an emergency is defined in
Okay.
terms of shortening time on a public meeting. So I don't think the requirement that people file their SCI 3 months after the fires occurred, would meet the definition of an emergency for an emergency regulation. Which, because of the timing here, we have plenty of time to notice our regulation with OAL and bring it back to the commission. Like with COVID, we didn't have that much time, but the situation was different that we thought it was justified to have an emergency meeting in that case on shortened time and adopt the emergency regulations without noticing them with OAL first.
Okay. If I may suggest that for the meeting that's next week, is it next week? Our next full commission meeting, just to keep things moving on track, we adopt, and we could, as a Law and Policy Committee, support the adoption of the Ventura and Los Angeles regulation. For this other, I think it just would be, I would definitely have the full commission be the language instead of the chair, nothing against the sitting chair, and really be clear with commissioners, here's what existing law is, here's how this changes it, and so that it's clear. We still have authority under our existing world to act as quickly as possible, but this is for very much more specific circumstances. That would be my suggestion. And it doesn't have to be adopted in a rush on the second one, not rush, on next week's meeting. It can be perhaps noticed more, whatever. I think that's less urgent to adopt than the immediate time frame. And I welcome our colleagues' thoughts. I'm comfortable with it as long as it has the full commission instead of chair. And it's not, I'm trying to anticipate just what are the unforeseen limitations. We still have some quick acting ability. This is just for very specific emergency defined circumstances. And as long as that's clear. That's my recommendation. A little word salady, but there.
I think that makes sense. Do we have any public comment as LA County or any of the other counties or stakeholders planning on making public comment? Sounds like we don't have any public comment. Before making a recommendation, I'd like to hear more from LA County, City of LA, et cetera, perhaps even San Diego County, as to what they think on this. I'd like to hear more about how the fire is impeding their officials' ability to file and their filing officers' ability to receive paperwork. I think it's important, at the very least, just to have that in the record. Just because we didn't have that at the last commission meeting, there was basically a request without any basis for the extension, except the obviously serious circumstances related to the fire. I think it'd be important for the public to have that evidence if 2 years, 3 years down the line, they want to know why the commission acted to extend this deadline.
Completely defer to you on if perhaps there's some intentional outreach. I mean, I guess I would say they're busy right now. This might not be on their radar, and to ask them to show up at public comment or provide a written letter, I just would be, we might want to be somewhat informal, and I would still act because I think it's help them. That would be my thought on this first one. That's just specific to them. I don't know that this is high on their radar, and I wouldn't want to delay giving them an extension in hopes that they can provide more robust public comment. But I bet if we reached out over the next week, perhaps someone would be able to share some feedback. How does that sound?
That works
Yeah.
for me. Why don't we go ahead and do that? And then one thing I would note with 18720, or I should say, I think this is option 2. Whichever option is specifically tailored towards LA County and Ventura County, we might want to adjust the language in the second to last sentence that says it's going to be extended by 60 days, and change that just to June 1st, 2025, because it's possible, because there's 31 days of May, that someone could interpret that as the deadline being extended to May 31st instead of June 1st, 2025. That's just one kind of technical change to make there.
Mr.
Commissioner
Chair,
Baker?
I was uncertain. I thought you were referring to getting more public comment for that regulation to be recommended, as opposed to the first one. Is that right? Did you want public comment on both of them from Los Angeles and Ventura, or was it just with respect to the?
I'd welcome public comment on both.
Got it.
I was looking for
Okay.
public comment in our discussion
Yes.
just now about the extension specifically for LA County and Ventura County.
Got it. Thank you.
Yeah, but I appreciate your alternative, and I think that makes a lot of sense.
So does public comment, so it's all good. But we might want to proactively reach out to them. Is good. Thank you.
Great. So we haven't had one of these law and policy meetings since June. So remind me, is there any sort of formal recommendation or direction that you need from us, or we can move on to the next item?
We don't need any direction. It's gonna be it's already on the agenda for next week. If you want to make a motion to support something, you can as a recommendation to the full commission, but it's not necessary.
Okay, perfect. Any public comment? Great. Why don't we move on to item 5, and that's going to be discussion of items for the next Law and Policy Committee meeting. Any items for the next Law and Policy Committee meeting? I'm very sad because the reality is probably
not
you
be
won't
there.
be joining us, so.
You'll have another
But
great
we'd love to
colleague,
still
hopefully.
consider whatever issue that, that you'd like to discuss.
Oh, thank you. I'm sure it'll be, the agenda will be just fine, and you'll have, hopefully, not an empty chair, but you'll have another colleague to work with you on it.
Excellent. Well, I'm sure there's going to be a lot of thank yous coming in the next month, but thank you so much for your service to the commission. It's, it's really something that I've cherished just in my 6-7 months here. It's been incredibly helpful to have you on these issues and on the dais right next to me.
Well, thank you. I've enjoyed it tremendously. I'm very grateful. I mean, the law and policy has tended to be a little bit more informal because it's just the two of us and the team, and I'm grateful to how we have the kind of exchange and ideas so that when we come back to the full commission, they'll add theirs, and some of them we've already thought of. So I've appreciated getting to work on this committee, and I'm glad I got appointed to it. And thanks for the work, everyone.
Okay, great. Any public comment on that item? Okay. Okay, we'll give him a moment. Okay, then I am going to move to adjourn.
Second?
Okay, Ms. Bo?
Commissioner Baker,
Aye.
Chair Silver.
Aye.
Meeting adjourned.